Yo, what's poppin', y'all? Welcome back to Crown TV Courts, brought to you by Crown TV and CrownTVNews.com. Make sure y'all go check out the website when y'all get a chance. I go by the name of Prince. I want to thank y'all, as always, for the continued support that y'all show this channel. We are less than 3,000 subscribers from reaching that 100,000 subscriber milestone, which is something that I could hardly fathom when we started this channel. So for everybody who's ever liked the video, shared the video, hit the Cash App, which is a rare occasion. We need to work on that. Share the channel with somebody. I greatly appreciate y'all. Now, a lot of people have been asking why we haven't touched on this yet. There are two reasons for that. Number one, I've been sick. I've been under the weather, so I haven't been able to do really anything that involves speaking. Number two, this is a very new case, y'all. There's not a lot of information being generated at this point. The only useful information that's been generated at this point is the actual indictment. So when you look at that and you look at the amount of content that's being made off of just the indictment, that should tell you what kind of content you're listening to. Now, I'm all for blogging, but we don't blog. We talk about the actual information that is happening in the courtroom. So if we are delayed, that is why. So we're going to talk about that. I also want to talk about some misinformation that's going around regarding a protective order and somebody signing into protective custody, which are two different things. These things are miles apart. A protective order is an order that all co-defendants in federal cases sign, saying that they agree not to talk about the evidence in this case, which may or may not include confidential sources, informants, or witnesses, which are also three different things. A confidential source, which is actually mentioned in this document in this case, is a law-abiding citizen. This is not a criminal. This cannot be a co-defendant. This is a law-abiding citizen who provided information. This is much different from a cooperating witness and also a confidential informant. A confidential informant and a cooperating witness may be involved in criminal activity. So I just wanted to clear that up. A protective order is about protecting the evidence in the case from the public, and this is why you don't hear federal co-defendants ever discussing their case, because they signed this agreement. So we're gonna move on and get to this indictment. All right, so we're looking at a 7-count indictment. All 5 co-defendants have been charged in each count. So as we go through the counts, I won't be saying who's been charged, so just keep a mental note of that. All 5 co-defendants charged in each count. Also, we know that this is all related to one event. This may change in the future with a superseding indictment or multiple superseding indictments, which very well might happen in this case. Count number 1 is murder in the aid of racketeering. This is a violent crime in the aid of racketeering. Whenever you have a racketeering case that involves a murder, for everybody who is involved with that murder, this now becomes a death penalty case. So the minimum penalties for this count is either the death penalty or life in prison. Now, why it's either or is that this decision is up to the Attorney General whether or not he wants to pursue the death penalty. Now, one thing a lot of people don't understand about the death penalty is that it is very controversial. This is something that they want to get rid of. This is something that they don't want to give out. So in cases like these, the death penalty is more often than not pursued. If you go back in recent history and look at the types of cases that have gotten the death penalty, you'll see what I'm talking about. This is not the type of case where an attorney general usually chooses to pursue the death penalty. Now, whenever you have a group of individuals who can be linked together or associated, in fact, it becomes an enterprise according to the feds, and this becomes a racketeering case. This is very important, y'all. Now, always stress this. This is not about a name. This is not about calling yourself something. All you have to do is be able to be associated to be considered an enterprise. So now this becomes a racketeering case, and all of the violent crimes become violent crimes in the aid of racketeering, and now carry stiff penalties in the form of mandatory minimums. I hope y'all got all that. Moving on to count number 2. Count number 2 is causing the death of a person through the use of a firearm. This is pretty self-explanatory. This can also be penalized by death, life in prison, or any number of years, and it's also up to the Attorney General whether or not he or she wants to pursue the death penalty. The reason why I keep saying this is because I know there are family and friends of these people who are listening to these podcasts and listen to us talk about this case and may be concerned when they keep hearing us talk about the death penalty, the death penalty, the death penalty. So we want to give them some comfort. These are usually not the type of cases where an attorney general is going to pursue the death penalty. Count number 3 is conspiracy to commit murder. This has to do with the plotting and the planning of someone's murder. This is not the same as murder. This carries a maximum of 10 years. Count number 4 is assault with a dangerous weapon resulting in serious bodily injury. If y'all remember, there were 2 other people who were shot. This is for the one that they are calling victim number 1, and this charge carries a max of 20 years. Count number 5 is carrying, brandishing, and discharging a firearm in furtherance of a crime of violence. That last part is important because it makes this a 924C, which is an enhancement which comes with mandatory minimums now. So for carrying a firearm, you get a mandatory minimum of 5 years, and remember, you don't actually have to be the person carrying it to be in possession of it in a federal case. For brandishing a firearm, you get a mandatory minimum of 7 years, and for discharging a firearm, you get a mandatory minimum of 10 years, and those are all going to be handed out respectively, meaning where they apply to each of these defendants should these defendants be convicted of this charge. Count number 6 is identical to count number 4. This is assault with a dangerous weapon resulting in serious bodily injury. This is for victim number 2, or the second person who was shot and not killed. This also carries a maximum of 20 years, just like count number 4. Count number 7 is another 924C that is identical to count number 5, carrying, brandishing, discharging a firearm in furtherance of a crime of violence. This is an enhancement. It carries the same penalty for each level of participation, whether that be carrying, brandishing, or discharging. So those are the 7 counts in the indictment. Again, this is the only information, serious information, that is available in this case. More information will come. We got to be patient, y'all. We got to stop reaching for straws. We got to wait. Y'all let me know what y'all think about this in the comments. This is just a brief overview of the indictment. Again, I want to thank everybody for the support. Please hit that Cash App. Please hit the like button. Please share a video. Please share the channel with somebody. Let them know we out here. It's the Crown Prince. Peace, y'all.